Respond to my distinguished colleague and friend from Virginia. And in the first place, it's important for us to remember, yes, we are a bicameral Congress. Yes, in order to pass legislation, you've got to have something that passes the House and passes the Senate and is signed into law by the President. But the fact is that there are a number of ways to accomplish this. Yes, it's certainly true that one way that we reconcile competing versions of legislation passed in the House and Senate respectively is through a conference committee. It's not the only way. It is one way. It's also true that under Article 1, Section 5, Clause 2 of the Constitution, each body of Congress has the power to write its own rules for its own operation. The way the rules of the Senate are written are such that in our current posture, in order to get to a conference committee, it requires unanimous consent. That means all of us have to agree that it's a good idea to take that particular route. But we don't have to take that route. There are other ways that under the rules of the Senate would allow us to address differences in the House-passed budget and the Senate-passed budget without going to conference. We could, for example, take up the House-passed budget right now. We could debate that and discuss that. That's a way of addressing this that doesn't require us to go to conference. But going to conference right now under the rules of the Senate, as they apply to this set of facts, does require unanimous consent. There are a handful of us who are not willing to grant that consent if, in fact, the intent is, the possibility remains that they use that as a backroom effort to raise the debt limit, a backroom effort that would not require utilization of the Senate's traditional rules, including the 60-vote threshold that often applies. So you're asking us to agree with something with which we fundamentally disagree. Now, my friend from Virginia has also made the argument that it is somehow unreasonable of us to make this objection because of the fact that none of these amendments were brought up in connection with the budget. I actually think the argument goes exactly the opposite way. Because the debt limit was not part of the deliberations in this body on the budget, and because the debt limit was not part of the deliberations or the final text in the other body in connection with the budget, there's no need for the conference committee to address the debt limit. There certainly is no need to circumvent the otherwise applicable rules of the Senate that would govern this in this posture, in this context. Now, Madam President, I'd like unanimous consent to engage in a colloquy with my colleague, the junior senator from Texas.
Without objection.
And I'd ask my colleague from Texas, who has on occasion expressed similar concerns to those that I have just expressed with this kind of posture. So I would ask my friend from Texas, is it in fact your intent, is it your objective to be obstructionist? Are you trying to obstruct here? Are you in fact being unreasonable in raising these objections?
I thank my good friend from Utah, and I would note that each of us, a number of senators have raised this objection, have focused on one thing and one thing only, which is whether the Senate can raise the debt ceiling with just 50 votes or instead whether the Senate can do so with 60 votes. That is the issue here. We are perfectly prepared to go to conference on the budget right now, today. That is a red herring. That's not what this procedural fight is about. Every time that this motion has been asked for by the majority, the minority has risen up to protect the rights of the minority, because ordinarily, to raise the debt ceiling, it would take 60 votes. And if it takes 60 votes, what that means is that the 54 Democrats are not able to do so on a straight party line vote, freezing out the Republicans. Right now, the Democrats have stated they believe the debt ceiling should be raised with no preconditions, no negotiations, no structural changes to our out-of-control spending that is bankrupting our country. And what the minority senators have said is that at a minimum, if we are going to raise the debt ceiling, it should be subject to a 60-vote threshold so that we have a conversation about fixing the deep fiscal and economic challenges in this country. And it is indeed the majority who, I will give credit for candor, does not wish to say, no, we will take the debt ceiling off the table, because it is, I believe, the Democrats' intention, if this budget process goes to conference committee, to use reconciliation as a backdoor procedural trick to raise the debt ceiling on 50 votes. I think that would be a travesty. But I think much of this debate is clouded in smoke and mirrors. Much of this debate is clouded in obfuscation. This is a simple question. Should the debt ceiling be able to be raised with only 50 votes, or should it require 60 votes, which will necessitate some compromise, some discussion? And on that question, I'm quite confident that the American people are with my friend from Utah, are with the members of the minority who believe that if the debt of this country is going to go higher and higher and higher, we need leadership in this body to fix the problem rather than simply putting more and more debt on our kids and grandkids.
And if I might ask, Madam President, of my friend from Texas, why wouldn't one want the usual rules of the Senate to apply? That is, why would one want to block or prevent the 60-vote threshold from applying with a debt ceiling increase, just as the 60-vote threshold applies to so much of the most important, the most contentious, and the most closely watched legislation that moves through this body?
Well, the 60-vote threshold, as my friend from Utah knows well, was designed to protect this institution that has been called the world's greatest deliberative body, and to ensure that the minority has a role in the discussions. And on this issue, I think that is critically important, that there are few, if any, issues we will address that are more important than the question of the unsustainable debt that is threatening the future of our kids and grandkids. The natural reason why the majority would want to get around the 60-vote threshold is without a 60-vote threshold, the majority doesn't need to listen to this side of the House. And President Obama has been very, very explicit. The president has said he wants the debt ceiling raised with no negotiations, no discussions, no conditions, nothing to fix the problem. You know, in the last 4.5 years, our national debt has gone from $10 trillion to nearly $17 trillion. What we are doing is fundamentally irresponsible, and the majority would like to be able to keep doing it without making any prudent decisions to stop the out-of-control spending, stop the out-of-control debt, fix the problem. And the only way they can do it is to use a procedural trick to shut down the minority. I don't believe that is consistent with our obligations to the constituents who elected us, and I don't believe it's consistent with the responsibility of all 100 senators to take seriously the obligation of protecting the fiscal and economic strength of this nation for the next generations.
The senator from Texas is a seasoned constitutional scholar, a graduate of Princeton University and of Harvard Law School. He went on to clerk for Judge Michael Ludig on the United States Court of Appeals for the Fourth Circuit, now general counsel to Boeing. He later clerked for the late Chief Justice William H. Rehnquist on the United States Supreme Court. Having argued a total of 9 cases before the United States Supreme Court, the senator from Texas is a seasoned litigator, in addition to being a scholar of the Constitution. And so I would ask my colleague a couple of questions related to that. It's occurred to me sometimes as a lawyer myself that there are sometimes some similarities between being a senator and being a lawyer. They're not perfect, but we are retained for a limited period of time, in 6-year increments generally, to represent a group of people. And it's our job to do what we can to act in the absence of those people. In my case, there are 3 million people from my state, the state of Utah. They can't all fit inside this chamber, so I'm one of the people who's elected to represent them in their absence. So I'd ask my colleague from Texas, number one, how do the people of Texas feel about the idea of raising the debt limit yet again? In particular, how do they feel about the idea of raising the debt limit yet again without any kind of permanent structural spending reform put in place as a condition precedent to that action? And finally, how would the people of Texas feel if, as their elected representative, representing those people here in this body, you surrendered one of your biggest bargaining chips? You abandoned one of the tools that allows you to make sure that we don't raise the debt limit too casually, too cavalierly, without putting in place the adequate precautions.
I thank the junior senator from Utah for his overly generous comments and very kind characterizations. And indeed, I think that the analogy he drew is really quite apt, that every lawyer in representing a client has an obligation to zealously represent that client. that owes a fiduciary duty to that client. And I would suggest that all 100 of us owe that same fiduciary duty to the men and women in our states who entrusted us with the obligation of coming here and fighting for them, because the 3 million citizens of Utah could not all be on the floor of the Senate fighting. The junior senator from Utah steps in their shoes to fight on their behalf. And I feel confident that the citizens of Utah, like the citizens from Texas, would be horrified at the notion that this body would continue raising the debt ceiling over and over and over again without even trying to fix the underlying problem. You know, this Senate floor has a long and storied history. There have been great men and women, great leaders of this country who have walked on this floor, and yet each generation, going back for centuries, has managed to avoid saddling the next generation with crushing debts. You know, I am reminded of the senator from Utah's very distinguished late father, Rex Lee, who was the Solicitor General of the United States, who was widely considered one of the finest U.S. Supreme Court advocates to have ever lived. He was an individual who took the obligation of zealously representing his client deeply and near and dear to his heart. Your father's generation, my father's generation, did not leave us with crushing debts, did not leave us with debts from which we could never escape. What has happened in the last 4.5 years is qualitatively different. It's qualitatively different from what has happened in the last 2.5 centuries in this country. No other generation has said to their kids, to their grandkids, and to their grandkids' grandkids, we are going to rack up so much debt that you're never going to be able to escape. My wife and I are blessed. We've got 2 little girls at home, 5 and 2. The idea that Caroline and Catherine are going to spend their adult days working to pay the taxes, to pay off the debt that we are spending recklessly right now, I think is profoundly immoral. It is profoundly irresponsible. And I cannot tell you how many thousands of Texans, men and women across the state, have said the exact same thing. Stop bankrupting the country. Stop bankrupting our kids and grandkids. That's the fiduciary duty we have to fight for, to defend, is to stand for the 300 million Americans for whom this body, Congress, has been racking up a massive credit card debt that threatens to imperil the security of this country and the future generations in America.
Are you suggesting that we stop altogether the practice of issuing U.S. Treasuries to finance the operations of government? Are you suggesting that we go without a budget, or that we simply halt the issuance of Treasury instruments altogether? Or are you suggesting something more long-term?
Of course we shouldn't halt the issuance of Treasuries. And of course we shouldn't forswear any and all debt. The Constitution provides that the federal government can incur debt. And there has been a long history of incurring debt, particularly to meet extraordinary circumstances. In wartime, we have had a history of incurring debt and then of paying that down. What is important to emphasize is that there's a qualitative difference in what's happened in the last 4.5 years. We have always had some degree of debt in this country. But one of the challenges is that at times, 1 million and 1 billion and 1 trillion can seem like the same number. They all end in illions. They all sound big. And yet, the difference of $10 trillion, where the national debt was 5 years ago, and just shy of $17 trillion, where we are now, is fundamental. It is structural. Our national debt exceeds the size of our entire economy. You know, we look over at Europe, we look at Greece, we look at the nations of Europe that are collapsing because their elected officials were not able to be responsible. They spent money they didn't have. They built up so much debt they couldn't repay. And there comes a point where every decision to address the debt is an ugly one. where the debt hole is so deep, as some of the nations in Europe are discovering, that the answers are either drastic cuts to spending or massive tax increases or massively inflating the currency. And every one of those outcomes is ugly, which is one of the reasons we've seen rioting in the streets of Europe. Now, thankfully, the United States is not yet in as deep a hole as some of the nations of Europe. And that's why we need leadership now to stop the out-of-control spending by addressing the deep structural problems. If you keep spending money you don't have, if any of us ran our families, our households, our businesses, the way the federal government is run, we'd be bankrupt. We'd be sleeping under a bridge. What it takes, I believe, is responsible leadership, and I hope bipartisan responsible leadership. Republicans and Democrats coming together to say, let's live within our means. You know, that's not a terribly conservative principle. That is a principle that has been common sense in this country for centuries, and it's one, sadly, we have gotten away from in the last 4.5 years.
Here we're really talking about a procedural strategy. We're not even talking about an outcome here. We're talking about the full utilization of the procedural rights of each and every member of this body. We have been asked to give our consent, effectively to vote for, a procedure that people on both sides of the Capitol have now admitted could and may well be utilized as a mechanism for raising the debt limit in a way that circumvents the 60-vote threshold of the United States Senate. It seems to me that that's troubling, and if we analogize that yet again to other circumstances where you have to represent someone else, that can be troubling. So I asked the senator from Texas, let's suppose when you were representing clients in court, let's say in the United States Supreme Court, when you're in the position of the petitioner, for example, you have the right as the petitioner, meaning the person filing the petition for a writ of certiorari. You're seeking review by the Supreme Court of the United States. Review is granted. After review is granted, a briefing schedule kicks in, and you have the opportunity to file the first brief. That's your prerogative as the petitioner. The other side then has about a month to file its brief, and then you get something that the other side doesn't get to file. You get a reply brief. Procedurally, under the rules of the Supreme Court of the United States, that's your right. That's your client's right. Once you've got a case up in front of the Supreme Court and you're in the middle of the briefing schedule, what would you say to a client if you came to them and said, you know, my opposing counsel has just asked me to waive my right to file a reply brief, even though that's my right to do that, the client has asked me to do it. What would the client think if you actually said, I'm not going to file a reply brief, even though procedurally I have every right to do that?
My friend from Utah asks a terrific question, and it's a question, you know, procedural rules, whether in a courtroom or in the United States Senate, are designed to protect substantive rights. And ultimately, the 60-vote threshold is designed to protect the substantive rights, not of the senators. We are not here on our own stead. We are instead here representing the constituents who sent us here. What the majority is asking us to do by asking for unanimous consent to allow this to go to conference and to set it up for them to raise the debt ceiling with 50 votes is the majority is asking for the 46 Republicans on this side of the aisle to give away our right to speak. To say, we will cede to the majority the ability to do whatever it wishes on the debt ceiling, and in giving away our right to speak, what we're really giving away is not anything that belongs to us. It is the right of 26 million Texans to have their voice heard. And for us to agree with the majority, yes, we will hand you the ability to make this decision on the debt ceiling without ever again consulting this side of the aisle, would be very much like the situation you asked about. And I don't know how the senator from Utah would answer a constituent in Utah who said, Senator Lee, why did you give away my voice? Why did you simply hand to the Democrats the ability to decide how much debt the United States should have, to raise it, and why did you essentially give away my seat at the table, because it's not your seat, it's not my seat. It is the seat of the millions of constituents in Utah and Texas and each of our home states who sent us here. And the idea that we would willingly give up their right to speak is inconsistent with the obligation we owe the men and women of Utah and the men and women of Texas.
I would suspect that in most circumstances, a lawyer giving up that procedural right would be committing malpractice. Now, perhaps a lawyer in that circumstance could say to the client, well, you know, I'm going to do this because opposing counsel has asked it of me, and I want to get along with her. I want to make sure that I maximize our chances of settling this litigation, perhaps before the litigation has been completely resolved. But if that were the argument that opposing counsel was making to me, I suspect that I would tell the client, if that's the case, if our objective is to try to settle the litigation rather than wait until the court resolves it, then by doing that, by giving up that procedural right to file the reply brief, I'd be forfeiting a lot of bargaining power that I would otherwise have. And so too here. We would be forfeiting a tremendous amount of bargaining power relative to the budget discussions, relative to the debt limit discussion, a discussion that needs to take place under full sunlight and not under cover of darkness. It needs to take place in the two chambers and not in some backroom deal. That's what we're talking about. That's why these procedural rights are so important. Now, you can disagree with the rules of the Senate, and a lot of people do. You can want to change the rules of the Senate, and there are some who do, some even in this body. But the fact is that the rules are what they are. We have the power to make those rules under Article 1, Section 5 of the Constitution, and we have the power to change those rules under Article 1, Section 5 of the Constitution. But those rules being what they are, those rules being in place as they are today, those rules having the application that they do as of this very moment, you can't ask someone like me or my friend from Texas to give our consent to something that we think is fundamentally wrong and that we think will substantially diminish the bargaining power that we have in undertaking that policy approach that we think is most necessary today. Now, one of the questions that I've been asked by some of our friends on the other side of the aisle, and a few of our friends who are even on the same side of the aisle as you and I, is, you know, you're a Republican, I'm a Republican, why can't you guys just trust that the Republicans who control the House of Representatives will adequately secure your interests? Why don't you therefore feel comfortable effectively forfeiting your right to a 60-vote threshold on the debt ceiling debate?
Well, I think that is a reasonable question to ask, but there are a number of points that are relevant. Number one, there is a considerable history of the debt ceiling being raised through reconciliation. And indeed, it has been done in 1986, in 1990, in 1993, and in 1997. So the danger that we are acting to prevent is not a hypothetical danger. It is a danger that has proven accurate. Those who say, well, simply trust the House, you know, the House, they are elected to represent their constituents, and each of the 435 members of the House has an obligation to exercise their best judgment to represent their constituents. Whatever they choose to do, and I would note a number of members of House leadership have publicly on the record suggested that they might well be amenable to raising the debt ceiling through reconciliation. So given their public statements, the scenario we are raising is a possibility that the House leadership has suggested may well be on the table. But more fundamentally, regardless of what the House chooses to do, Senator from Utah has an obligation to 3 million citizens of Utah to represent their views. And I don't believe it would be responsible for him to give up his very eloquent voice, for me to give up my voice, for any of us to give up the voice of the citizens we're represented. You know, I'm reminded of meeting an individual at a gathering of Republican women back in Texas about a month ago. And this individual was a veteran who had fought in World War II. And he was there and was introduced to everyone and received a standing ovation. And a story was told about how he had been injured in World War II, grievously injured. And he was in a hospital, and two doctors were debating about where to amputate his leg, whether to amputate the leg above the knee or below the knee. And this soldier was unconscious, and he awakened in the middle of this conversation between two doctors about where to amputate his leg. And this soldier began to participate in that debate. And unsurprisingly, he had a very strong view that he would very much prefer they not amputate the leg. And he expressed that view vociferously to the doctors who were having that debate. And as he expressed his view, he ended up prevailing in that argument, and they chose not to amputate his leg below or above the knee. And to this day, he walks with a limp. He doesn't walk as well as he might if he had not been injured, but he was able to save that leg because he had a voice in that debate, because he spoke up, and his interests concerning his leg were acutely different from the two doctors who were debating it without his voice. Now, I think he had every right to participate in that debate because it affected him, it affected his future, it affected his life. And just so, I think the 3 million citizens of Utah have every right to participate in this debate, and not simply to be told, trust the other body of Congress. They have an independent obligation, but you, my friend, the senator from Utah, have an obligation to your constituents to make sure their voice is part of this debate.
Indeed, we each have an obligation to utilize our own voice and to make our own judgments with regard to the best course of action to take in any debate, in any discussion. The problems in this country are significant. There's not one of us in this body that would like to minimize them. There's not one of us in this body that isn't concerned about these problems. Each of us might take, might advocate, might firmly believe in a different course of action. But it's precisely because of the diversity of opinion in this nation that this nation is great. It's precisely because of the viewpoint diversity that we have in this body that this body has been called the world's greatest legislative body, deliberative legislative body. We need to make sure that that remains. In order for that to be the case, it is appropriate that members of the Senate who have a good faith, genuine disagreement with an issue as to which a unanimous consent request has been made, that they come forward and they object. On that basis, I object, and I will continue to do so as long as it remains necessary to ensure that the debate that we have surrounding the debt limit occurs under the regular order of the United States Senate. Thank you, Madam Chair. I yield the floor.